The Safety Act in McHenry County has been an abject failure. That's according to the McHenry County State's Attorney's Office. I chatted with Patrick Kenneally, the state's attorney out of McHenry County yesterday, and he shared with me some of the findings that they were able to glean from the data over the past year. Welcome in. It's Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell, get the podcast anywhere you get podcasts, Illinois in Focus, and get the headlines at thecentersquare.com. All right, so let's get into this. The Safety Act report by the numbers from McHenry County. And the Safety Act in McHenry County has been an abject failure, the press release says. Not only has it failed to deliver on what its proponents promised, and that's the court system, being more equitable, it's actually experienced the exact problems predicted by critics. Some background here. Obviously, the Safety, Accountability, Fairness, and Equity Today Act, the SAFE-T Act, it was passed with a broad package of criminal justice reforms and regulations on police, and this was during the January 2021 COVID legislative sessions, where you had the Illinois House at a convention center in Springfield to allow for social distancing and all that. But they ultimately passed this, and it went through, and then they changed it again. Then there were lawsuits filed by counties across the state. The law was put on hold from going into effect until last year in September. The Illinois Supreme Court ruled in favor of getting rid of cash bail. And what this does is, the traditional cash bail system was, if you're arrested for a crime, the judge would assess the allegations against you and then would levy some kind of bond or bail. And then you would pay that bail and you could get out pending trial. Well, people argued that that was unfair for those who didn't have money getting charged with low-level crimes. So they spelled out these categories of crimes that people could be detained for without any cash bail, and people who could go free without any cash bail. Regardless, Illinois is the first state in the country to eliminate cash bail across the entire state, not just in various jurisdictions. So I chatted with Patrick Kenneally, the McHenry County State's Attorney, yesterday, and he talked about this report and gives us his thoughts on ultimately what some of the takeaway is.
Well, the proponents of the Safety Act promised sort of two things which would seem to be counterintuitive. So one, they promised that crime would not increase and they would be releasing more people charged with crimes pre-trial. That was dubious from the start, and many of the critics pointed that out. And what we found in McHenry County, and one of the things about the criminal justice system is that it's sort of like the most disaggregated system of government that we have in Illinois. And what that means is that sort of what happens in McHenry County isn't necessarily what's going to happen in Cook County, and what's happening in Cook County isn't necessarily what's going to happen in Lake County. We have different officials who execute the laws and who are elected, different judges who are interpreting the laws and enforcing the laws. And so there's going to be sort of different outcomes wherever you go, just because different communities are going to elect different people, despite the fact that the laws are the same. But what we found in McHenry County is that of those people who were released on pretrial, so we took a period of time in 2022 and 2023, and then we took a period of time just after the Safety Act, so the exact times just sort of separated by 1 year, and we asked ourselves, okay, how many people released on bail recommitted an offense while they were on bail during that term? And then we say, okay, how many people on pretrial release after the Safety Act committed an offense during that term? And what we found was that there was a 30% increase in crime by those on pretrial release compared with those on cash bail. Another interesting fact is that they promised that this was going to reduce the jail population because more people were going to be being released because there were so many nonviolent, low-risk offenders who were just being held by the court indiscriminately because the court callously held them because they weren't able to pay. What we actually found is that the jail population has increased in McHenry County. So on the eve of the Safety Act, on September 17th, 2023, there were 204 people in the McHenry County jail, And on September 15th of 2024, which is exactly 1 year later, accounting for the leap year, there were 216 people in the McHenry County Jail. We've seen a 280% increase in failures to appear during the first 5 months of the Safety Act. And one of the things that not a lot of people were talking about is the fact that somebody is going to have to fund the court system if defendants are no longer going to do it. So one of the ways that we funded the court system is that every time somebody would get charged with a crime, they would put down a deposit of 10% of the bail. So if your bail was $5,000, you'd put down $500. This money was then used to pay things like restitution to victims if and when the case was decided that the defendant was guilty of something. If people are no longer required to put down any deposit of money, what that means is that even if you say, hey, you have to pay a victim this amount in restitution, at the end of the day, none of that, a very little amount of that money is being paid. And we can sort of say, well, like, look, we're going to send you to the collectors and it could affect your credit score. But that's that's not getting the job done. So what we've seen is a 35% reduction in restitution that's paid out to crime victims, as well as a criminal justice system which is not being fully funded. And what that means is that it's not being fully funded in terms of court costs and otherwise. And what that means is that if the defendants who use the system are not going to be required to pay for the system, then the non-criminal taxpayers are going to be the ones that are going to have to fund it. And so that's sort of where we're at.
So again, that's McHenry County State's Attorney Patrick Kenneally chatting with him yesterday and looking at some of the news release that McHenry County put out from the state's attorney's office. Again, a 30% increase in those on pretrial release compared with those on cash bail, an increase in the jail population, a 280% increase in failures to appear, and a 35% reduction in restitution paid to crime victims. And goes on to say that the problem with the Safety Act, written by public defenders and advocates for criminals, is that it denies county judges elected by the communities affected by the alleged crimes to have discretion to detain defendants charged with most crimes, no matter how high risk. Rather, in most cases, a judge has no discretion and must release the defendant. One needs not be a professor of criminology to understand that mandating judges in all circumstances to release high-risk defendants pre-trial is a misguided and unreasonable policy, a policy that proceeded from the ideology of a privileged group of advocates who dictate criminal justice legislation in Illinois, overcoming common sense. But when I asked, some of the different types of crimes that, we have people failing to appear after being released with no cash bail, Kenneally discussed more about the Safety Act and what exactly it does, and really touches on that discretion. He says judges are not allowed to exercise.
One of the things that the Safety Act did is it sort of cut the criminal code into sort of two different sections. One of the sections are detainable offenses, so those are offenses that you can be detained for. Another section of offenses are non-detainable offenses. So an example of a detainable offense, which is a low-level offense, would be violating an order of protection or a domestic battery. That's probably the most common crime that we see at the McHenry County Courthouse. So I would hazard to guess and infer that a lot more people are being detained on misdemeanor domestic batteries than they ever were in the past, and a lot more people who are more high-risk defendants who are charged with these non-detainable offenses. So those types of defendants who are committing the types of offenses that are sort of repeatable offenses, which are drug crimes and property crimes, and who, despite the fact that they have been involved in the criminal justice system for quite some time, don't find the deterrent aspect of the criminal justice system to be a significant impetus to their behavior. Despite the fact that they're high risk and despite the fact that these are very real crimes that cause people to suffer, they are being released, of course, to commit more crimes because a judge cannot hold them. So even if a judge is convinced with respect to somebody who's charged with, let's say, a fentanyl-based offense, that they are going to go out and continue to engage in drug trafficking, a judge cannot hold that person because it's within this realm of non-detainable offense, which is sort of one of my ongoing critiques of the Safety Act, which is if you want to get rid of cash bail, that's fine. And I guess we could all sort of adjust to that. But what you can't do is say that determine an outcome before it has a chance to be adjudicated and argued. What you can't do is say it doesn't matter who this person is or the risk that they pose to the community. If they've committed X crime, they're automatically released, because that's just an entirely arbitrary decision. And the whole point of a judge is to weigh the facts and make a just determination for the communities that elected them, and they are being deprived that in many instances under the Safety Act.
So again, Patrick Kenneally, state's attorney from the county of McHenry, talking about the Safety Act a year after and some change when it was put into place by the Illinois Supreme Court following legislation signed by the governor that was ultimately blocked by lower courts from being implemented, getting rid of cash bail across the state. Proponents of it, again, say that, listen, it's inequitable and people getting charged with low-level crimes couldn't afford to get out of jail and they would sit there and languish. But opponents saying that, listen, the judges need more discretion to be able to keep people who are a flight risk or people who are possibly going to fail to appear and so on, which in McHenry County, those numbers showing that 280% increase of failures to appear, reduction in restitution payments, 30% increase of those on pretrial release compared to those with cash bail, increased jail population, just some of those things. All right, we'll definitely be hearing more about that, I imagine. It is Illinois in Focus. I'm Greg Bishop, and get the podcast anywhere you get podcasts.